Please be seated. The court is now back in session. I know the defense counsel is on his feet. You may proceed, counsel, for Mr. Kyu Sampon.
Merci.
Yes, thank you, Mr. President. Very briefly speaking, I'd like to apologize to Judge Cartwright. I did not understand the meaning of your question relative to indigents. And then I understood afterwards when I spoke with my team. I believe that the misunderstanding happened when I said that there was no risk that he would go underground or that Kyu Sampon would flee. And what I wanted to say at that moment, was that he did not suddenly become rich. He didn't have the means to escape, and that he's not sitting on a pile of gold. That's what I meant. But what I wanted to really say, and this is maybe what led to this misunderstanding, his family is committed to finance his day-to-day living expenses, which will be rather modest. And I would also like to tell you that if you so desire, Monsieur Kyu Sampon would like to say a few words supporting his request.
The President. Yes, Mr. Kyu Sampon, you may proceed. Thank you very much, Mr. President. My respect to judges of the bench, all parties and members of the public. First and foremost, I would like to confirm that I do not have any passport. I haven't had passport for a long time. When I left the forest to reside in Thailand, I only had my identification card and the electoral card. That is the first thing I would like to make it clear. Secondly, I would like to inform the court that all my children in the present day are working. They are earning their living, but not much, but just sufficient for their living. We live in one flat together. We share the bill. We share the cost of food. We share the living cost. One of my children has a child who is working in Phnom Penh, and they also send the money back home to help share the cost of family. And I hope that once I am released on bail from the court, I am going to live with them, and I am sure that they will be able to feed me on the daily life. Thirdly, I would like to inform the court as well that my wife, when she come to visit me in the detention center, she traveled by motorbike. And if it is necessary that I participate in the proceeding, when the court summoned me to participate in the proceeding, I will be able to take the moto with her to come to this court. This is what I would like to inform the chamber, and I will comply with all the conditions imposed by the chamber on me when I am released on bail. And especially, I would like to reassure the chamber that I will be present in all the proceedings upon call summoned by the chamber until the court is concluded. Thank you very much, Your Honor. President, next, I would like to hand over the floor to the prosecutor to make a statement or present arguments in response to the application and submission by the defense team for Mr. Kyew Sampon, together with the statement made by Mr. Kyew Sampon. You may proceed.
Thank you, Mr. President, and good afternoon again, Your Honours and Council. I hope the Chamber may be willing to be somewhat flexible with the time allotted to us. We're at a double disadvantage. We haven't filed a written submission, unlike the defence for Mr. Kyew Sampon, and also the Chamber has granted them more time than half an hour. But with that, I will proceed. Your Honours, the co-prosecutors oppose this application because it is our view and our respectful submission to Your Honours that the conditions in Internal Rule 63(3)(b) continue to exist for a continuation of Mr. Kyew Sampon's detention, and we respectfully submit Your Honours should exercise your discretion in this matter carefully and look into these elements in Rule 63(3)(b, apply them against the evidence and elements which I will put before you, and order Mr. Kyew Sampon's continued detention. There are several matters which require addressing, and I will start with this issue of alleged uncertainty or lack of foreseeability in the current proceedings and the completion of the current proceedings, which my friends on the other side submitted together with an argument about delays. If I can make very brief legal submissions, and this is necessary because, again, we haven't filed a written brief. The cases relied upon by our learned friends in relation to this issue of foreseeability originate or are judgments of the European Court of Human Rights, and a review of the cases relied upon illustrates that they're not relevant for present purposes. First, on the issue of certainty, of legal certainty, our learned friends rely on a number of cases, among them Velichko and Russia, a judgment of the 15th of January 2013, Tsitsirigos and Greece, a judgment of the 17th of January 2012, and Sarkov and Russia, a decision of the 16th of July 2009. What is common to these decisions, Your Honours, is that they concern the legal certainty arising from provisions of legislation. That is, these are cases in which the European Court of Human Rights stated that domestic legislation must provide sufficient legal certainty as to conditions of detention. So they're not relevant for present purposes in that part. The cases do deal with the issue of indefinite detention, and of course we all agree that indefinite detention is contrary to law and of course contrary to justice. And each of these cases turn on specific facts where there had been a lack of diligence and there had been undue delays in the prosecution of crimes before domestic courts. I should also state that these cases are equally not applicable or of extremely limited relevance because they largely deal with pre-trial detention matters. And if you look at them, you will note that the majority of the cases cited by my learned friends deal with cases of pre-trial detention during investigative proceedings. And so they're not relevant for present purposes as a matter of law. The same applies to cases referred to in paragraph 23 of our learned friends' submissions, cases of Letellier in France, Labita in Italy, Valderrama in France. These cases, again, deal with pre-trial detention and facts very different from those before, Your Honours. Needless to say, all of the ECHR cases deal with allegations of crime that could not be compared to the case before, Your Honours. These cases are far less complex and simply turn on their own facts. Additional cases cited in that section, again, all pre-trial decisions: Piatkov and Russia, Dogan and Turkey, Leontiuk and Romania, and I referred earlier, I believe, to the case of Velichko in Russia. So all of those cases referred to in paragraph 23, again, largely deal with issues of pre-trial detention and turn on matters of domestic law and domestic criminal procedure. They're not relevant for present purposes insofar as allegations of lack of certainty or delay are concerned. Turning to this issue of alleged lack of certainty and delay, we submit that Your Honours should adopt the approach adopted by the pre-trial chamber in relation to this matter. And that approach focuses on the length of detention and whether that length of detention is proportionate to the circumstances of the case, including its complexity and including the conduct of the entire procedure. The pre-trial chamber dealt with these matters in its decision on Mr. Q Sampan's detention appeal of the 3rd of July 2009. The document reference is C26/5/26, and the paragraphs that relate to, for present purposes, are from 68 to 70. Again, the pre-trial chamber revisits that matter in their decision of the 30th of April 2010, again on an appeal by Q Sampan. This document is number C26/9/12, and the relevant paragraph is paragraph 44. So it is our respectful submission that the view of length of detention...
The President, could you please identify the document numbers as well as the relevant year and page for the record, please?
Yes, Mr. President. The second decision was a decision of the 30th of April 2010, and the document number is C26/9/12. The relevant paragraph is paragraph 44. I apologise, I don't have the ERNs handy simply because a paragraph number is an even more precise reference, but I can provide ERNs if Your Honours prefer immediately following the hearing. Now, turning to this issue of certainty and length of time, it is our respectful submission that the arguments put forward by our learned friend with respect to the lack of foreseeability simply do not stand scrutiny, just as any argument about delay does not withstand scrutiny. This trial commenced on the 21st of November 2011, that is in relation to evidentiary proceedings. And, of course, on the 21st of November 2011, Your Honours heard the opening statements. Today is the 167th day of hearings. And in the intervening period, Your Honours have heard more than 50 witnesses, and that is not including experts who testified in relation to fitness of accused. It does not include the testimony of DC Cam witnesses on authenticity of documents. The proceedings have indeed taken place in an orderly fashion. Of course, we have experienced challenges arising from delays caused by illness of the accused, but there can be absolutely no credible suggestion that at any stage of this case there has been undue delay or a lack of diligence on the part of the authorities. This case should be viewed, of course, on its own facts, and it is often remarked that this is one of the most complex criminal cases ever prosecuted. But if one were to engage in a comparative analysis, then in our respectful submission, the more appropriate cases to look at are cases tried before the other internationalised or international tribunals dealing with cases of mass crime, and not domestic cases dealing with a charge of single murder or robbery or fraud. This information is publicly available, so it can be reviewed by all parties and, of course, by Your Honours. But our own review of cases tried at the ICCY indicates that in more than 50 cases, accused were detained for periods of 5 years or longer, while at the ICTR, more than that period of detention of 5 years or longer occurred in at least 31 cases. In fact, the average lengths of time for trial at this tribunal are significantly longer than what is projected by Your Honours in relation to completing the current trial. Again, there can be no credible suggestion of uncertainty or unforeseeability in light of the recent hearings and in light of the decision Your Honours have rendered on the severance of the case. We have received guidance from the Supreme Court chamber in relation to two options for proceeding to an expeditious completion of the trials before the ECC. And Your Honours have taken that guidance. You have held extensive hearings with the parties, and you have issued a fresh severance decision. And I'm sure in due course the reasons for that decision will present a plan for the completion of proceedings. And turning on to another aspect of the length. I apologise, we seem to have a problem with the audio system, but I will proceed. I think we may be online now. I hear the French channel in my headphones. That's why I'm... My apologies, Your Honours, for that delay. Looking at reasons that these trials take so long, of course, cases of mass crime are inevitably complex. They involve thousands of documents, they involve large numbers of witnesses, and extensive legal arguments. And the record of this case shows that Mr. Khieu Samphan, through his defence, has vigorously defended against the charges, has filed numerous appeals, procedural requests, challenges to the admission of evidence, etc., all of which, of course, is within his right. But in our submission, against that background of the complexity of the case and of the diligence with which all parties have proceeded, it is simply unconvincing to argue that there have been undue delays and that we face a situation of uncertainty. Just in recent months, the submissions from Mr. Khieu Samphan have included appeals to the Supreme Court, challenges to the admission of new evidence, submissions on the applicability of witness statements, objections to other materials, etc. All of which, of course, are examples of a legitimate exercise of his rights to a fair trial, but all of which, of course, have an impact on the overall conduct of the procedure and have to be taken into account when the Chamber considers whether or not there has been undue delays in proceeding. My learned friend also made reference to an early decision to sever the proceedings against Kangik Uv alias Doig and to suggest that that led to a delay in the investigation of this case. This is actually a new argument that was made as part of the 87-4 application, so we've had limited time to consider it. But if one looks at the written records filed by the co-investigating judges during the investigation of Doig, one finds that close to 300 written records were put on the case file by the time the closing order against Doig was issued. Many of those documents, if not most of them, relate to broader issues in this case. So there was in fact no delay to the other accused from the decision to forward the proceedings against Doig to trial separately. In short, it is our submission that when one considers the complexity of this case, which is one of the most complex criminal cases ever prosecuted, when one considers the passage of time since the alleged crimes, the volume of evidence that is required to be considered to arrive at the truth, the complexity of legal submissions, such as submissions on the applicability of crimes in the 1975 period, and all the various objections that are put forward by the defence and various legal arguments that are put forward by the prosecution, one cannot credibly argue that there has been undue delay in the conduct of these proceedings, contrary to the outcomes of cases put forward by our friends from the European Court of Human Rights jurisprudence. There has been absolutely no undue delay or lack of diligence in the present proceedings. Now, turning to the 5 grounds, which of course are disjunctive in Rule 63(3)(b)(1), and taking as our starting point the Supreme Court Chamber decision of the 6th of June 2011, we note that what is required upon a fresh application for release is a meaningful review, a full and meaningful review of whether the conditions in Rule 63(3) continue to be satisfied. And this can be found in paragraph 49 of the Supreme Court Chamber's decision, and this is the decision, of course, on the immediate appeal by Khieu Samphan on a prior application for his release. The document number is E50/3/1/4. Our time is limited, and I do note that in their application, the defence for Khieu Samphan have not alleged that the condition in Rule 63(3)(a) is no longer satisfied. That is the condition that there are well-founded reasons to believe that the accused may have committed the crime or crimes alleged against him. Given that rule is not raised by the defence, there's no allegation that that provision is not satisfied, but that their application rather deals with the conditions in 63(3)(b), I will deal with those 5 conditions, which, as I indicated, are disjunctive. I will start by looking at 63.3b1 and 2, and I will deal with these at the same time. Of course, these provisions deal with the need to prevent the charged person from exerting pressure on any witnesses or victims, to prevent any collusion between the charged person and accomplices of crimes falling within the jurisdiction, and also to preserve evidence or to prevent its destruction. We submit that there are elements now on the case file which indicate that a release of Mr. Khieu Samphan would create a
The President, I don't know why English channel is now coming through my ears. There is no Khmer at all now. The President, co-prosecutor, you may now proceed. I don't know whether other people in the courtroom had experienced the same thing, but perhaps things now go back on track. You may restate what you just indicated, please.
Thank you, Mr. President. So I will restate last couple of sentences. I will deal first with the conditions in Internal Rule 63.3b1 and 63.3b2. The first condition deals with or requires a consideration of whether detention is necessary to prevent the accused from exerting pressure on witnesses, to prevent any collusion between him and any accomplices, whereas 63.3b2 deals with the need to preserve evidence or to prevent its destruction. And I submitted, Your Honours, that there are now elements on the case file which indicate that a release of Mr. Khieu Samphan at this stage in the proceedings would create a material risk that pressure on witnesses or victims may occur, that there may be collusion with accomplices or alleged accomplices, and that evidence may be endangered. Your Honours will recall that on the 15th of August and the days following, we heard testimony of witness Sa Siek. In the course of her testimony, Madam Sa Siek confirmed the contents of a report issued by the Office of the Co-Investigating Judges, which indicated that this witness and her husband, now deceased, but also a witness in this case, had been approached by Mr. Khieu Samphan's wife and asked questions about matters at issue in these proceedings. This incident should be viewed in context. I'll give first the reference for that OCIJ report that I referred to. This is A110/Roman numeral 2. Correction, Your Honours. The correct document number for that report is D369/40. D369/40. And that document indicates a visit by Khieu Samphan's wife to Madame Sa Siek and her husband. That information is contained at Khmer ERN 00498 437, French ERN 00498 434, and English 00492 720. And as I said, this incident should be viewed in context. On the 10th of January 2008, the co-investigating judges sent a memorandum to all the parties in this case, and this is document A110/2, in which they informed the parties that they are prohibited from conducting their own investigations during the conduct of a judicial inquiry. That instruction is contained at Khmer ERN 00157-736, French 00157-743, and English 00157-740. And the instruction is clear. I quote, this is addressed to Nuon Chia's defence, but a copy is sent to all of the parties. Quote, "You have informed us of your intention to conduct your own investigation and indicate that you reserve the right to interview any individual." A little bit further down, quote, "Again, it appears necessary to distinguish this legal system from that of other international and common law systems. Before this court, the power to conduct judicial investigation is assigned solely to the two independent co-investigating judges and not to the parties. There is no provision which authorises the parties to accomplish investigative action in place of the co-investigating judges." This memo is dated 10th of January 2008. In the period that followed, both Sarsiak and her husband, now deceased, Mr. Tar Sot, were interviewed by OCIJ. Their records of OCIJ interviews can be found in D200/6 for Sarsiak and E3/464 for Tar Sot. In December 2009, we filed an investigative request for these witnesses to be re-interviewed. This document is D256. And now returning to the OCIJ report that I made mention of earlier, it indicates that by early March 2010, Khieu Samphan's wife had made the trip all the way to Battambang to speak to these individuals about events that were described in their OCIJ statements. She confirmed, that is, Madam Sarsiak confirmed this incident in her testimony, and that can be found in the transcripts of the 16th and the 20th of August. The 16th of August transcript, document number E1/109.1, and the relevant section of my questioning of this witness on this issue starts at Khmer ERN 00837-158, French ERN 00836-969, and English 00836-845. The 20th of August, transcript number E1/110.1. The relevant portion begins at Khmer ERN 00837-047, French 00838-672, and English 00838-548. In those...
The President, co-prosecutor, you may read the ERN numbers again, and when it comes to ERN numbers and document identification, please slow down a little bit.
I do apologise, Mr. President. So those ERNs for the transcript of the 20th of August were Khmer 00837-047, French 00838-672, and English 00838-548. In summary, Your Honours, this is an instance where one of the individuals that Mr. Khieu Samphan now proposes to reside with upon his release has made contact with witnesses who had been interviewed by OCIJ, witnesses who were of interest to OCP, and in circumstances where the co-investigating judges had given clear instruction that parties are not to engage in their own investigation. Time is limited, so I can't read all of the relevant passages, but if Your Honours examine them, you will note that the purpose of that visit was to clarify certain events that allegedly Mr. Khieu Samphan could not recall. One can reasonably infer that this visit, in fact, was at the behest of Mr. Khieu Samphan because it was apparently designed to clarify certain facts on his behalf. In our submission, this gives rise to a clear basis to conclude that if released, Mr. Khieu Samphan, living in his family home, together with his family members or on his own, may seek to contact witnesses or accomplices and may seek to interfere with evidence. His propensity to do this is illustrated by the incident I described. Turning to 63(3)(b)(4) and the risk to Khieu Samphan if released, we respectfully submit that this risk continues to exist. It was found to exist by the pre-trial chamber in 2009 and in 2010. To state the obvious, allowing Mr. Khieu Samphan to live at his family home and to travel to and from the ECC creates an unacceptable risk. It makes him an easy target to anyone who would wish to harm him. And it would be a very simple matter to predict the times at which he is travelling to and from the court for anyone who wished to cause him harm and thereby prevent these proceedings from coming to an orderly conclusion. The attitudes towards this accused and other alleged leaders of the Khmer Rouge continue to be coloured by strong feelings of revenge on the part of victims. Contrary to what my learned friend submitted, the surveys that are before Your Honours, and here I refer to surveys that we have filed previously, so not the new evidence that I put forward today, confirm that not just the civil parties, but the public at large, the Cambodian people at large, continue to harbour strong feelings of revenge towards the accused. Document E50/3/1/1.1.4, which is a December 2010 study based on interviews with over 1,000 respondents, only a fifth of whom were civil parties, found that approximately 40% of people in the general population continue to harbour feelings of revenge towards the former Khmer Rouge and the Khmer Rouge leadership. And that document contains additional statistics that confirm these findings and the basis and provide a basis to find that an unacceptable risk does exist, and that if Mr. Khieu Samphan were to be released, the proposed arrangement would simply not provide sufficient security for him. On this, one has to keep in mind the earlier incidents to which my learned friend did refer. The attack on him, on Mr. Khieu Samphan, which occurred in 1991, this is described in D29, attachment 96. Contrary to what my friend says, the contemporaneous media report shows that while there was some suggestion of a politically motivated initiation of unrest, that very quickly a mob swelled to 10,000 people who smashed windows and attacked Mr. Khieu Samphan, who found himself, according to this report, beaten, whimpering and cowering half inside a bedroom closet. By the year 2000, when Mr. Khieu Samphan contemplated addressing the public in relation to alleged Khmer Rouge crimes, he made it a condition that either the international community or an independent organisation guarantees his safety. You will find this in D29, attachment 95, another document that is on the case file. It is our submission that at this stage of the proceedings, with all of the information that is now publicly available about the crimes and about Mr. Khieu Samphan's role therein, and this close to the completion of the trial, it would simply be an unacceptable risk to release him, to expose him to these risks, and potentially jeopardise a completion, an orderly completion of this trial. I would note that the Supreme Court chamber, in their consideration of this, of a different condition, of a condition of risk of flight, found all of these matters to be relevant. And Your Honours will find that at paragraph 54 of the Supreme Court chamber's decision. And we agree with the Supreme Court chamber. In our submission, all of these factors go towards establishing both an unacceptable risk to Mr. Khieu Samphan's own safety and, by extension, under Rule 63(3)(b)(3), which relates to ensuring his presence, they create an unacceptable risk that his presence cannot be or may not be secured if he is released. I'm mindful of the time and I will bring my submissions to a close very briefly. Further on the issue of risk of flight, my learned friends have submitted that Mr. Khieu Samphan has happily and willingly submitted himself to the jurisdiction of this court and that there is no reason to doubt that he would continue to do so if he is released. We respectfully disagree. There are a number of prior statements by Mr. Khieu Samphan which indicate that he is not willing to participate in these proceedings and that he in fact challenges the very legitimacy of these proceedings. There are two statements of relevance in particular. Document E3/583, an October 2007 interview of Mr. Khieu Samphan. The relevant references are Khmer 00424179, French 0064334, and English 00680014, where in October 2007, Mr. Khieu Samphan, commenting on Nguyen Chia's arrest, says the following, quote, "Being old, he is seemingly disrespected by such an arrest and detention. My feelings are slightly affected by this. I am referring to the legitimacy of the tribunal. Firstly, I refer to our Khmer tradition in which we pay respect to our elders. At his age, he should not be prosecuted." A little bit further down. Secondly, I don't mean to argue right or wrong, but I have taken some law classes, and although I have not put them in practice, I am questioning the legitimacy of this tribunal. A second statement made in November 2006, E3/108, Khmer ERN 00347 038, French ERN 00613205205, and English 0000929. Quote, "What do you think about the upcoming trial?" Mr. Q Sampan's response, "I think we should learn from our history. We should put our national interest ahead. We should do everything for the interest of our nation. We should not listen to foreigners. We should follow Khmer traditional way of thinking. We have to ask questions like, is this tribunal the right thing to do? People who fought against foreigners will be charged for killings, people, and brought to justice. For example, myself. What will happen to me, and what did I do? They can prosecute me because they are now in power. Yet I want them to think as Khmer, not as foreigner. I want them to think about the interests of Khmer. Do not follow the United States. Do not listen to them." And finally, in another interview, D313.11.1, Khmer ERN 00807-474, French ERN 00826-496, and English 00815-896. Again asked about the creation of the tribunal, Mr. Q Sampan comments, "I have never supported the creation of this tribunal, but if they have already done so, I cannot say anything. I will not say anything because I will gain nothing. I do not talk about this. Let them do it because they have power. However, I still believe that only my people, the Cambodian people, can truly judge me, not these judges. These judges abuse their power and do whatever they want to, but Cambodian citizens still respect and love me." Your Honours, in our respectful submission, these statements, again taken in context and looked at together with the other evidence I referred to about attempted influence on witnesses, do create an unacceptable risk that if released, Mr. Q Sampan may not be available for a continuation of the trial, or that he may interfere with witnesses or evidence, and further, that his release may lead to a disruption, an unacceptable disruption of public order. In our respectful submission, to release him now, at this stage of the trial, only months before its conclusion, and shortly before judgment is to be rendered by your judgment, by your honours, would create clearly an unacceptable risk, a risk that should not be taken, and your honours should therefore exercise your discretion to keep Mr. Q Sampan detained, while of course assuring him that we will all together endeavour to bring this trial to an expeditious conclusion. I apologise for having taken extra time, and I thank your honours.
The President, thank you. Next, we would like to hand over to counsel for Mr. Kyu Sampon to reply to the submission made by the prosecution.
Thank you, Mr. President. Well, to respond to the different arguments that were raised by the prosecution, I will start with jurisprudence from the ECHR that I referred to earlier, in order to support the fact that when the ECHR examines the length of provisional detention, it examines not only this in view of the investigation, but also takes into account the judgment as well. And now we are in the judgment phase. This is the meaning behind the story of Valderrama case, decision by the ECHR of 26 January 2012. That was also what I meant when referring to this, which is to say that this court takes into account not only the investigation phase, but also the judgment phase in ruling on provisional detention. And the ECHR also said in that regard that whether there's delay or not, risks associated with provisional detention diminish over time. So the prosecutor asked that our request be rejected, saying that this is a very complex case involving mass crimes. It is normal that the case is long, and in fact all cases of this nature before international courts are always very long. He even added that the defense had the audacity of defending itself, which I don't even believe the prosecutor can believe in that kind of argument. But now, getting back to this idea of a complex case of mass crimes, and that trials are also very long before other international courts, I would like to remind all of you that your chamber is the only one to prosecute facts so long after these facts were committed. We are 35 years after the events that you're going to have to assess. And there is no other international court that has been in a similar situation, which somehow makes all of these comparisons a little bit not well grounded. 35 years after the facts, I mean, that's a long time. And there's also the fact that you are prosecuting people who are also very old. So I don't believe that there are other examples in other international courts of similar situations. For example, Kirsanpan is 82 years old. And this you should also take into account when you're going to hand down your decision. And without trying to frustrate you, there's also the context of uncertainty that we have to take into account. And I believe that there is also no other example of international courts that has faced as many difficulties as we have faced here, whether it be financial difficulties, whether it be political difficulties, or even the interpreter strike. All of these difficulties, you cannot just cast them away as if they had never existed and continually saying that everything is moving along smoothly. There are difficulties, and you are assessing facts that are ancient and people who are quite aged. Kirsanpan has been detained for the past 5 months and 5 years and 4 months, and there are sufficient guarantees for you to release him on bail. The prosecutor also said that Monsieur Kirsanpan has challenged the legitimacy of the court, supposedly. And did you see this yourselves? Up until now, I don't think that this was the case before this chamber. And his defense was here all the time to see this. And there is a document that was mentioned. This is another interview that of Kirsanpan a few days later, after the interview mentioned by the co-prosecutor, E3/588. It's an interview conducted by the Voice of America by phone, and Kirsanpan says, let the tribunal summon me, no matter when. They just have to summon me, and I will go. So it's clear. It's perfectly clear. And things of course, didn't happen that way, but had it been that way, he would have come then. So I also believe that in order to decide on this issue with a clear mind, you should keep in mind that we are facing a double-sided trial, adversarial as well as accusatorial. In France, the judgment phase is much shorter in France because the tribunal relies more on the investigation, and the people who criticize or not this kind of trial often say that the trial is almost a rereading of the investigation. Here we are in a mixed situation. You take time, and of course it led to quite a few misunderstandings, especially from on the part of my colleagues who have experience in the Anglo-Saxon system. It created difficulties, as you know. For example, you had to listen to witnesses. So all of this had consequences on the length of the trial. And the two-headed aspect of this trial also should be taken into account. And finally speaking, the prosecutor tells us, or gives us an example that showing that Khieu Samphan could exert pressure on witnesses. And he refers to this lady who came to testify. And you probably remember Miss Siak. Yes, she was very clear. She said, and I quote here, the segment when she answers Antaguise at E1/109.1, French ERN 008-36971. And this is Antaguise putting the question to her: if I understood your answer properly, she encouraged you to say all of the truth on what you knew about Mr. Khieu Samphan. And Siek's answer: yes, that's so. That's what she said. She said that if the investigators put questions on Khieu Samphan, we had to say the entire truth. So this is exactly how the newspapers relayed this information. And I have here an article from the Cambodia Daily from Phnom Penh Post, and it says clearly that Khieu Samphan was said to cooperate with the tribunal. So I think that in terms of putting pressure on witnesses here, this is a complete fantasy on the part of the prosecution. These are the observations I wish to make to respond to the prosecution. Thank you.
The President, thank you. The hearing to hear the submissions by parties to the proceeding concerning the application for Mr. Khieu Samphan's release on bail has come to an end. The Chamber wishes to thank you, all the parties to the proceedings. The Chamber will examine this, and the decision on this will be rendered in due course in accordance with Rule 82, subparagraph 3 of the internal rules. The Chamber wishes to also thank you, all people concerned, including staff of the trial chamber and the interpreters, for doing their best to support the smooth conduct of the trial proceedings, I may now pronounce that the court is adjourned and that security personnel are instructed to bring Mr. Kilsampon back to the detention facility and have him return to the courtroom by Monday, the 22nd of April at 9 a.m.